recognize Senator Cruz here, but a brief word. In October, I can't remember when it was in 2013, I got a call from Senator Schumer. We're going to change the rules regarding circuit court nominations. And it was relatively late in the evening. And I said, please don't do that. There'll be no going back, and you'll live to regret it. My view is that set in motion a lot of things that have taken the Senate in the wrong direction. No longer do you require 60 votes. That started with circuit courts. The belief in 2013 was we're going to pack the D.C. Circuit Court with people friendly to our cause. That's where all litigation regarding the government goes. And nobody thought you'd lose in 2016, including me. I've gotten to know the president, but I voted for somebody I really wouldn't know if they walked in the door. The bottom line is 2016 gave an outcome different than everybody in the country thought, except the people who voted for the president in the right amounts in the right states. And isn't that ironic? The American people actually get a say. And from that day forward, there's been an effort to say that election didn't happen, it's not legitimate. Donald Trump is not really the president. As much as I was disappointed that Barack Obama beat John McCain, I accepted the outcome. I voted for his nominees. There is no way you'll ever convince me that Amy Coney Barrett is not qualified using any reasonable standards of qualification. If I applied to Justice Sotomayor and Kagan the standards you're being imposed upon every Republican nominee since I've been here, I wouldn't have voted for them. Senator Leahy, to his credit, voted for Justice Roberts, and that's sort of been the end of it. So the qualification test to me seems to be dead and buried with everybody but me. And I'll have to reevaluate where I am. I want to be fair, but it's kind of silly to play a game nobody else is playing. Now, as to me, in August of this year, I was asked directly, what about a vacancy? I said, after Kavanaugh, everything's changed for me. I'm not going to sit on the sidelines and watch one of our nominees be destroyed after showing respect for two Democratic nominees. That is not right, and I'm not going to do that. As to Judge Barrett, the time periods we've talked about extensively, the same party as the president, the same party as the Senate. You know, Senator Cruz is very smart on all this stuff. I made sure you had a chance to test her. You did, and I want to compliment each member of the Democratic side for being firm but not going down the Kavanaugh road. And we have two panels waiting on us. We'll do whatever the committee likes. I'd prefer to hear from them, but Senator Cruz.
Mr. Chairman.
Yes, sir. After Senator Cruz, we'll go to Senator Durbin. Yes.
Thank you, Mr. Chairman.
It could be heard too at some point.
Promise you everybody will be able to talk.
Thank you, Mr. Chairman. I think it is important for the record to reflect that moving forward on this nomination is consistent with 2 centuries of precedent and tradition in the Senate. Numerous Democratic members of this committee have given speeches. I see they have charts prepared to give more speeches, all attacking the legitimacy of these proceedings. And as John Adams observed, facts are stubborn things. The scenario of a Supreme Court vacancy occurring during a presidential election year is not a new thing. It has occurred 29 times in our country's history. Presidents have made nominations all 29 times. The precedent is unequivocal and uniform. When a vacancy occurs in a presidential election year, the president makes a nomination. That includes Republicans, that includes Democrats. A total of 44 people have served as President of the United States. 22 of them, half, have made a Supreme Court nomination during a presidential election year. What has the Senate done? Again, the precedent is clear. Of those 29, 19 of those occurred when the President and the Senate were of the same party. Of those 19, the Senate confirmed 17 of them. The precedent is clear for a long, long time that if the President and Senate are of the same party, the Senate, in all but extraordinary circumstances, confirms that nominee. How about when the Senate and the President are of different parties? That's happened 10 times. In that circumstance, the Senate has confirmed the nominee only twice. 2016, which our friends on the Democratic side invoke, and I understand why they invoke it. They were frustrated. 2016 was one of those instances in which President Obama was a Democrat, the Senate was in control of the Republicans. They had differing views on the kind of justices that should serve on the court. And so the election resolved those views. One example that has been pointed to, Senator Klobuchar just pointed to it, Senator Harris at the vice presidential debate previously pointed to it, was Abraham Lincoln. We are told that Honest Abe, the founder of the Republican Party, showed the example for why we should not be proceeding on this. I think it's worth noting that example misses a lot of the story. So Abraham Lincoln, in 1864, 27 days before the election, Chief Justice Roger Taney passed away. Roger Taney, by the way, had been the author of the infamous Dred Scott decision, an abominable decision of the Supreme Court. So suddenly there was a vacancy 27 days before the election. Senator Klobuchar and Senator Harris before her both pointed out the fact that Abraham Lincoln did not make a nomination in those 27 days. What both of them omitted was that the Senate wasn't here. The Senate had left. They had gone home. This was not the age of jet travel. This was not the age of commuting every weekend, jumping on a United flight. They were gone, and the Senate would not return until December. So there was no Senate physically present to confirm that nominee. When the Senate did return in December, Abraham Lincoln nominated in December a justice to fill that seat, Salmon Chase, which the Senate confirmed the next day. 24 hours later, they confirmed him. I would note also that Abraham Lincoln was in the midst of a presidential reelection, and as Doris Kearns Goodwin writes so beautifully in Team of Rivals, he was very good at assembling the political coalition he needed to win, and so he had multiple factions of the Republican Party that were splintered. Some things haven't changed from 1864. And Lincoln had multiple players that wanted that Chief Justice seat, all working really hard to reelect him and dangling the nomination out in front of each of them. So Salmon Chase had been his Treasury Secretary. Salmon Chase had been a pain in the rear to Lincoln. And as a result of this vacancy, Salmon Chase went out and campaigned like crazy for Lincoln to get him reelected because he wanted the nomination. None of that should be shocking as a matter of history. And there are many members of this committee that enjoy being students of history. But to suggest that that is somehow a precedent and that requires us not to fill this vacancy now is, well, I actually can't put it better than the Washington Post, who fact-checked Senator Harris on this claim. And the Washington Post, not exactly a right-wing bastion, the Washington Post conclusion was that Senator Harris's argument, quote, wasn't exactly true. So I recognize that our Democratic friends wish a different president had been elected in 2016. I'm sympathetic to those arguments. I recognize that our Democratic friends wish there was a Democratic majority in the Senate, but the voters decided otherwise, and so this committee moving forward is consistent with over 200 years of history and precedent.
I wonder in our time who is the Salmon Chase of the Republican Party? So many to choose from. Senator